What is considered property for someone who died? When someone dies, their property must be passed on to their heirs and beneficiaries. Everything that a person owns individually will be considered their property upon their death. This includes personal property such as cash, stocks, vehicles, clothes, furniture, jewelry, etc., as well as real property such as land, homes, apartments, condos, buildings, etc. Some assets will be subject to a process called probate, where the distribution of property is monitored by the probate court. However, some property will pass automatically to a co-owner or the deceased person's chosen beneficiaries upon their death. Other property is going to pass privately through a trust. Examples of assets that will not be subject to probate include 1. Any property that is jointly owned, such as real estate and bank accounts. 2. Payable-on-death, POD, or transfer-on-death, TOD, bank accounts, investment accounts, and retirement accounts. 3. Proceeds from life insurance policies or annuities. And 4. Any assets that are held in trust. What is a property called when someone dies? When someone dies, all the real and personal property that they own at the time of their death is called their estate or the decedent's estate. What happens to the property of a dead person? 2 primary factors affect what happens to the property of a person when they pass. The first factor is how the property is owned or how it's titled. As I discussed, certain assets are not subject to the probate process. These non-probate assets generally will be distributed as follows. 1. Trust assets will be distributed to the beneficiaries according to the terms of the trust. 2. Jointly owned bank accounts and jointly titled real property will be inherited by the surviving joint owners. 3. POD or TOD bank accounts, investment and retirement accounts, and life insurance policies will be passed to the beneficiaries designated on the documents for those assets. However, California law does make some exceptions to these rules when the non-probate assets are community property of a married couple in which the surviving spouse has a community interest. The second factor is whether or not the deceased person left a will or other estate planning documents. When the deceased person leaves a will, the probate assets will usually be distributed according to the terms of that will. But if the deceased person passes away without a will, then California's intestate succession laws are going to control how those probate assets are going to be distributed. Intestacy laws will also apply to probate assets not disposed of through a decedent's will, either intentionally or by mistake or omission. Once the estate's debts are paid as part of the probate process, any remaining property will be distributed to their heirs according to the state intestate succession laws. The intestacy laws establish a specific order in which family members are entitled to inherit and what portion of the probate estate they're going to get. For example, say the decedent died with a wife and 2 children. In that situation, under California's intestacy laws, the spouse is going to get all of the community property and 1/3 of the decedent's separate property, which is generally limited to assets acquired before marriage or inherited. The 2 children are going to split the remaining 2/3 of the separate property, with each of them getting 1/3. Here are some other examples of how California intestacy laws might distribute probate assets in different family situations. 1. If the decedent was married with no surviving children, parents, siblings, nieces, or nephews, all the property should go to the surviving spouse. 2. If the decedent was unmarried but had children, all property would be equally split among the surviving children. If one or more of the children died before the decedent, each deceased heir's children would take their share equally. 3. If the decedent was unmarried and did not have children, the decedent's parents would inherit the assets. If both parents predeceased the decedent, then the decedent's siblings would take. If there are no surviving siblings, then any surviving aunts and uncles would split the estate, and so on and so forth. Who are the heirs of a deceased person? Under California law, the heirs of a deceased person are any person who's entitled to receive the decedent's property according to the state's intestate succession laws. Typically, this can include any of the following: spouses, children, grandchildren, great-grandchildren, parents, siblings, aunts and uncles, nieces and nephews, in that order. It's important to distinguish between the term heir and the term beneficiary, where the word heir can only be used to refer to family members of a decedent. The word beneficiary means any person who's entitled to receive the property of the deceased person. When should I contact a probate lawyer? If you're dealing with the death of a loved one and you're unsure how their property should be distributed, you should consult. You should discuss the situation with a probate litigation attorney to understand your rights and what steps you may need to take to protect what your loved one intended for you and avoid losing your inheritance altogether. Have questions? At RMO, we protect people like you every day. Schedule a free consultation at rmolawyers.com or just give us a call, shoot us an email. Thanks for watching.